Our next presenter is John Gross from the National Association of Criminal Defense Lawyers. He is their general counsel. And we've had the opportunity at the Commission and formerly the task force to work with the group over the last few years. And they've been extremely helpful to our group. Last year we had your executive director and Jim Levine and Cynthia Orr came to the summit earlier this year. And it's a really good organization, and I want to thank the organization again for providing funding to help fund this program. John was prior to this work, served as a visiting professor at Syracuse University's College of Law Criminal Defense Clinic. Syracuse, I grew up in actually upstate New York, about 32 miles north, and Jim Boeheim, I think, may be the longest-serving basketball coach in this country. I had an opportunity when I was 14 years old to take a basketball clinic from him. Jim had told me, he said, if I grow about a foot or so, I may have a chance to play my senior year. Basketball was not my best sport. So with that, what I'd like to do is welcome John Gross, and if you would, please join me in welcoming John Gross. He's going to talk about basically some trends around the United States, and I think probably give a little bit of a summary of some recent cases and some possible studies. So please join me in welcoming John Gross.
Well, thank you very much, and I'm happy to be here as the NACDL representative. I know other members of my office would have liked to have joined and been in attendance today. They had some conflicts, but we continue to support the work of Jim and your organization, whatever you want to call it. You want to change it next year, that's fine. Just tell us who to make the check out to. It's good. And there's been a lot of wonderful speakers here today, and part of me is inclined to forget about the topic that I was asked to speak about and discuss something far more important, which is, I think, the shifting landscape of collegiate athletics and the realignment of conferences. I did not think I could hear anything more bizarre than TCU joining the Big East, and now I realize that A&M may no longer be playing Texas in the college football season if that goes through. So, although I'm tempted to do that, I will give you a brief overview of some of the things going on in other states around the nation. I think it's interesting, we had Amy Bach talk about this phenomenon that occurs, that people who operate within a certain system are incapable of seeing the deficiencies in it. So it's really, I really find it a privilege to have the opportunity to look not just outside of my own particular county. I practiced in New York, both downstate New York City and upstate, which are essentially two different states of mind and law. But not just at states, but as the federal system and across borders as well. And I think it really speaks volumes of the work that the Indigent Defense Commission has done to see the improvement that has occurred in Texas in just 10 years. And I say that because I'm well aware of the scope of Texas. It is a nation unto itself. As a matter of fact, there must be a common denominator that all of us speaking today have some fascination with American history. I remember reading a book recently, and nobody seemed to like the idea of Texas coming into the Union as one state. That seemed like a bad idea. But at the same time, they didn't want to break it up into too many states because that would upset the kind of north-south balance. But the one proposal floating around that was what is today Texas and Arizona, or most of Arizona, should be 6 states. And I thought at first, well, that's crazy. You can't have 6 states out of Texas. And then I thought about it some more, and I thought, no, you probably could, because Texas is like that. But the fact that you have 254 counties and you've made this progress, I think the nicest thing I can say about it is that I grew up in the Northeast and I'm based in Washington now, and I think folks in the Northeast obviously have this mindset about how things are done in the South and Texas and in other states across the country. And of course, they can't possibly do it as well as Massachusetts or New York. We're far smarter. We're more liberal. We've been here longer. I mean, we were the ones who originally signed that Declaration of Independence. And, you know, it's cute that you in Texas have your own independent republic and your own flags to go along with it. But seriously, I mean, we're really the ones who know what we're doing on this topic. And so my response to that has been to people to point out to them, I don't know, fun things like, oh, you know, in New York, your judge doesn't have to be a lawyer. What? Yeah. Outside of New York City, that's the rule. And, oh, by the way, you know when the judge is deciding whether or not to set bail on you or not? You're lucky if you get an attorney. You're probably not going to get one. And thank you all for the Rothgary decision, because I keep waving it at people in New York, particularly the judiciary, and saying, have you read this recently? Because you should probably have counsel there before you set bail on somebody. But so I think maybe the nicest thing I can say is this, is that if somebody asks me, would you rather be arrested and charged with a crime in New York or Texas? My response would be, what county? So I think that demonstrates that there's a lot of work to do in Texas, but there's a lot of work to do in New York. There's a lot of work to do across the country. You know, the other thing that comes to mind is that since we're all in a recession, we have this dual problem of legislatures wanting to cut budgets, but at the same time, as the Census Bureau has demonstrated, more and more folks are falling below the poverty line. So while we're seeing a reduction in funding for indigent defense, we're also seeing a rise in the need for it. And couple with that the fact that states just can't stop passing collateral consequence laws. They just love it. I mean, you can't stop a legislator from, you know, saying, were they convicted of a crime? All right, forget it. They can't, you know, do X, Y, Z. What, we left something off the list? Well, let's put an amendment on that. You know. So there's this rise in collateral consequences, and there's decrease in funding. So it's a tough situation out there for everybody. So that would be my first message. I think the problems that you're going to encounter in Texas with financing and reform, these problems are really endemic across the country. People come to me sometimes and say, well, who's doing it right? I don't know. Norman was able to identify some of the premier public defender agencies, but when you think about the scope of the problem and how small they are relative to perhaps other organizations within their own state, the problem is really daunting. There is some good news out there. The folks in Michigan have fought for a long time to get reform. They have a situation that looked a lot like Texas 10 years ago. They have a county-based indigent defense system with essentially no state oversight and no state funding. Now, they've finally gotten around to creating an Indigent Defense Commission by executive order that's going to meet, study the problem. You know, it's a start. Make some recommendations to the legislature about changing it. But this has come only after several scathing reports by the ACLU and some serious strategic litigation to try to change this system. But progress has been made. Some folks mentioned the situation in Luzerne County, Pennsylvania earlier today. Pennsylvania is very shortly going to be producing a legislative report that is pretty much an indictment of their county-based, non-state funded system. And I know when I've met with folks from Michigan and Pennsylvania, I have said, if you want to look to a way to transition out of this system, call the folks in Texas. They've got some ideas about it. They were in the same boat you were, right? It was Michigan and Pennsylvania. They're supposed to know how to do this stuff, right? No. Not doing such a good job. Also, and of course, the Pennsylvania case came out of this scandal involving judges in family court putting kids in detention, you know, and it was termed the cash for kids scandal, which at first I was like, well, I'm for that. Let's give cash to kids, whatever. Fund those programs. We need more funding for... No. That's not how it worked. Oh, let me change my mind. All right. A few other areas, states that I would highlight that have done some interesting things along the fault line of when you get counsel, because this seems to be a recurring battle that goes on. When do you get counsel appointed to you? Who makes that determination? Do you get counsel before a judge makes a bail determination? Do you get it after a bail determination? Should we be disposing of minor criminal charges at the arraignment, with or without counsel? Should jurisdictions be encouraging people to waive their right to counsel and simply dispose of the case in some way? Is that a good idea, a bad idea? Well, some states have some interesting positions on that. One, NACDL has been involved in a lawsuit in Colorado. I don't know if anyone knows this, but Colorado is the only state in the country that has this neat little statute that says that when you're arrested and arraigned, before you can apply for assignment of counsel, you have to meet with the prosecutor. You have to sit down in a room across from them and hear their plea offer to you. And if you would like to not accept it, then you can move on with the process of getting counsel. Big problem. We filed a lawsuit there, and it sounds like we might, I'll keep my fingers crossed, get some type of negotiated settlement. Because once again, thank you for Roth, Gary, v. Gillespie County, it doesn't seem like Colorado has a lot of ways out of this. It was a novel approach, but it was a novel approach in an attempt to avoid the expense of assigning counsel. And of course, Colorado has one of these problems, not unlike places like Texas and Michigan and New York, the big states that have very centralized population centers, where it might make sense to have a PD's office, like Harris County. Don't know why it took them so long to figure out why it made sense to have PD office in Harris County, but glad they're there now. But then you also have these very rural counties, right, where finding people to do the arraignment is a challenge. And so perhaps this was a better system, but not an improvement. Folks were certainly pleading guilty to things which would follow them because of the collateral consequences and without an attorney to advise them. Another state that's taken an even more technologically advanced approach to this would be Florida. And an NACDL report entitled 3-Minute Justice about the courts in Florida speaks about this particular process. But in Florida, what they like to do in busy municipal areas, and sometimes I hate to mention this stuff because it's streaming, and I trust all of you, you know, but God forbid it falls in the wrong hands. What Florida has done in a busy municipal areas is they've brought everybody in, they put them in a room, they show them a video about their rights and about the fact that they could waive counsel today and dispose of the case and go home. And then when they get out there in front of the judge, now nobody checks to make sure they're napping during this procedure, and I'm assuming it's given in English and Spanish. Hopefully you speak one of those two languages, or else this is going to be background noise. Then you get into the court and they give you a pre-printed form where you can easily waive your right to counsel and enter a plea of guilty because the prosecutor is standing right there. Assembly line justice. And again, people pleading guilty to offenses that will follow them out of that courtroom because of collateral consequences. And there is a lawsuit in Florida about that and whether or not that actually amounts to an intelligent and knowing waiver of counsel. And Maryland, an interesting situation in Maryland. There's litigation in Maryland right now about attorneys, the public defender, which is a statewide public defender in Maryland, being at arraignments where bail is set. Now, what's particularly interesting about Maryland is the PD's office is resisting the idea of staffing the arraignment parts. Now, that doesn't make any sense. Well, I don't know, you should maybe read Ordinary Injustice. It'll make a little bit more sense if you do. But the situation is that right now the Maryland PD's office is, because of budget cuts and attrition, stretched to their limit to provide legal services. And if they're asked to go in and staff arraignments, their fear is they won't get any more money. And things will get worse across the board for their clients. So my organization finds itself in an interesting position where we have a bit of a disagreement with the public defender in Maryland. But I understand why they have that problem. And I think it reiterates the necessity of, you know, all politics is local, most indigent defense is local too, right? Even though this is a statewide agency, they have political concerns that they're not going to get the funding to be able to meet this new mandate. So this becomes a concern, an unfunded mandate that they might have to meet, and you can see their reticence about it. And interestingly enough, that situation comes not from the Roth-Gary case, but from the actual statute in Maryland that describes the PD's obligations and duties. which is to represent people at all stages of a criminal proceeding. So they're stuck behind the statute there. In New York State, a couple of interesting developments. One being New York, who is a county-based system, who has very limited state funding. Most of it falls upon the counties to enact a system of indigent defense and fund it. New York, about a year ago, created what they call the Office of Indigent Legal Services, which was an attempt to create an office that will create and enforce statewide standards for indigent defense and do monitoring, and they were going to give them some money to give grants for counties that proposed innovative strategies. I shiver at the thought of this, for indigent defense. So they're using this model, this kind of carrot model, you know, without the stick so much, more the carrot, to say, if you reform your broken system, we'll give you a grant. We'll give you some money to implement those changes. Here's my problem with that. The counties that do it well will figure out how to do it a little bit better because they're already ahead of the curve. The counties who are doing it really poorly, who don't even know they're doing it really poorly, probably have no shot at this money, which means some of the places that do a good job will just do a slightly better job, and the places that really need reform, not so much. And then, immediately after they created this office and funded it, the legislature did exactly what you can expect a state legislature to do when it came back in session and looked at the budget. They cut the budget of it in half. Before the director had a chance to do anything, he had his budget reduced. So again, the problem sometimes is not the system in place. The problem can also be the funding. You can have a wonderful system on paper, but if it's not adequately funded, you're going to have chronic problems with it. New York State also has a case that's ongoing right now, which I think is somewhat groundbreaking. There was a similar attempt is ongoing in Michigan to create the same sort of litigation. But the New York Civil Liberties Union has sued a number of upstate counties in New York in a class action suit alleging a violation of the defendant's Sixth Amendment right to counsel under Gideon prior to the ultimate adjudication of the case. In other words, folks who had cases pending against them. Now, the response when they filed this lawsuit from the counties was to say, you can't adjudicate this. This is an ineffective assistance of counsel claim under Strickland. You have to wait until the case has been resolved. In other words, you have to wait until the defendants completely get shafted, have no practical remedy, and then you can sue us on an individual basis, which won't be successful. The case went all the way up to New York Court of Appeals. And the New York Court of Appeals recognized these defendants' right to sue under the Sixth Amendment as a distinct claim from ineffective assistance of counsel. And I think it's a very important decision, and it can serve as a model for future litigation. Because what it essentially does is it recognizes that the Supreme Court has a line of cases that talk about when counsel is completely absent. If there's a complete Sixth Amendment deprivation of counsel, right, they won't make a prejudice inquiry. And that deprivation of counsel occurs at the time, not at trial, at the time. So what this allegation was saying was that counties were simply appointing folks in name only. They never met with their clients. They never did any investigation. They never did any pretrial motions on the case. Thus, under the original Scottsboro Boys case, right, where this court said one of the most critical stages is the time between arraignment and trial, the allegation is this is a sham. There is no real provision of counsel. And the court, New York's highest court, said, yeah, that's a valid claim. If you can prove it, that's a Sixth Amendment violation, which is great because it unhinges this idea of the violation occurring only after the adjudication or only at trial. And in fact, it harkens back to the companion case to Strickland, which is People v. Cronick, where the allegation was that you had a lawyer who was assigned a complicated case involving wiretap and fraud and money transfers, who was a young lawyer, only had ever practiced real estate, and only got a month to prepare for this case that had been pending for 2 years. And while no one could point to a specific defect in the trial, the allegation was there's no possible way this attorney could have provided adequate counsel. And while the Strickland case was decided and that standard was announced, they dispensed with chronic. They said, we're not going to look at these other systemic factors that might go into a deprivation of counsel, except when counsel is completely absent. So in a sense, this is an attempt to go after a broken indigent defense system before it can do any more harm. It is reasserting Gideon in a kind of new and novel way. And it almost worked in Michigan, too. but it's a nice blueprint. So, the last thing... Yes, it's coming back around again after they did a weird Court of Appeals. We like it, we don't like it. Very indecisive. And finally, there's a lot of talk about possibly creating a role for the Department of Justice to initiate, at least under some proposed legislation, to be able to bring an action against states and counties for failure to implement Gideon. That this would be a kind of version of 1983 or the Americans with Disabilities Act or other types of unfair work practices and labor law, that the DOJ could become directly involved in these kind of broken systems. Which again, it's a great idea. It's been kicked around for a while. Some people have written about it. It's not a magic bullet. Nothing's a magic bullet. But it's a possibility, especially because the current Attorney General seems to be very supportive of these types of initiatives and is aware of the problem. Couple general trends to mention. I think people are starting to become more and more aware of overcriminalization as a problem. And I hate to mention this again. This is another one of those I'm afraid of who's going to hear this. Some legislators in conservative states, when you tell them, or when they find out rather, wait, we only have to give people counsel if they might go to jail? Oh, here's the idea. Let's take jail off the table. Now you don't get counsel, which creates this really weird possible world in which one could be charged with a misdemeanor. And here's I think I'm paranoid about this until I read about these immigration initiatives in places like Arizona and is it Georgia or Alabama? Which one is it, right? So if I was really thinking in a way which I would never want anyone to think, but you could charge somebody with a misdemeanor. If you looked at the immigration law, you could see that if they were convicted of that misdemeanor, they'd be deported. And if I was a judge or a prosecutor who really had it out for the guy, I might just say, you know what? Let's agree we're not going to give him any jail time. Good luck, sir. And the case could be tried without counsel. Now, I say that, and at the same time, I think that the Padilla decision opens up this window of opportunity to maybe at some point in the future start convincing folks that the right to counsel shouldn't be tied to the fact that you might spend a day in jail. Because to me, the way collateral consequences are right now, folks are in far more danger of losing a home, losing their kids, losing their job, losing their livelihood. I know plenty of clients who would have gladly spent a month in jail rather than get evicted, rather than have to go back to family court on a neglect petition, right? So there's this hope I have that Padilla will expand this conversation. Padilla itself is a challenge for folks across the country. What does it mean? How do local defenders adapt to this? How do they integrate Padilla into their practice? It's something where there's still fallout coming from it. You know, some folks think it means everything. Some people think it's not going to mean much when all is said and done either way. But we wait to see what happens. One of the other things I think that's important is this idea, I think two things. I'm very respectful of the folks who have done work on Innocence projects, and it has been a remarkable contribution to the kind of landscape of criminal defense, and it's highlighted some of the real failures of defense systems. But I think there's a push now to get beyond it slightly. I used to like to say in my clinic that I didn't run an Innocence project, I ran a not guilty project. And there's this idea of refocusing the attention back to the trial court. That yes, there are these horrible catastrophic injustices that we can point to because of DNA evidence. But there's a lot of other horrible things that happen. And myself, what I pointed to folks, or tried to, was the Troy Davis case, the man who was just executed recently. And this was clearly a case where people wanted to argue that he was innocent. And in fact, he had to demonstrate his innocence according to the Supreme Court and according to the parole board that he went before. But here's the problem with that, right? It's really hard to demonstrate innocence, ever. It's not that hard to demonstrate that you're not guilty if you have adequate counsel, adequate resources, adequate investigation, and adequate time to prepare for that trial. So putting the focus back on money well spent, right, at the start of a case. And tied into that, this idea, and there's a great paper that's come out by the Justice Policy Institute, which is subtitled The Cost of Under-Resourcing Public Defense, and it's available online. It's called System Overload. And it really talks about the financial costs. And here I know I'm preaching to the choir for the folks in Texas who've been doing the Indigent Defense Task Force now committee, or commission rather, work, is that there are real financial hardships in under-resourcing public defense. More time in jail, keeping people out of work, court inefficiency that's been talked about, that we need to see indigent defense not as this island, but as the spoke on a wheel. And actually, as some people have suggested, sometimes it's more like the hub of the wheel, right? It's all interconnected. The justice system, the defense organization that's working, the prosecutor, corrections, investigation, the courts, all of it work together. And if one part of that organization is broken, none of it really works that well. If you got one flat tire, you're not going anywhere. The other tires might be great. So it's this recognition, I think, that there has to be this systemic look and approach to things, and it can save folks money. And one of the last things I'll mention about that, and this is to reiterate what some of the other folks have said, is that, information is so critical, data. And I'm going to say this with full recognition of the consequences of it, but it's a little silly in some of our defender agencies that we don't keep time, keep numbers, and keep track of statistics. Now, I was a PD in Manhattan for about 8 years. And if you came into me and said, John, I want you to fill out a timesheet saying what you spend your days on, I would have gone ballistic. I would have said, that's not who I am. Do you think I don't care about my clients? You can't quantify what I do. Where's my union rep? I want to see him right now. We had a union. That's serious. But I get that. I get that. But at the same time, the example I give to folks is that I have a 2-year-old at home, and we were going to the beach over the summer, and I ordered him a bathing suit from Old Navy. It was very cute. And I ordered it online. And I got an email confirming my order. I got an email from UPS telling me when it was going to ship. I got another email telling me that it was en route. I got an email telling me when it was expected. I got 5 different emails. I knew where this package was more than I knew where my kid was during the day. Okay? Right? UPS walks around with a tracking device where you sign for things. Okay. The fact that I can go to a correctional institution and ask where my client is, and they say, I don't know, he's in transit. We got count. He might be on his way here. You'll have to wait. You got to be kidding me, right? I mean, to some degree, we're a little bit in the dark ages about this, but it requires a tremendous shift in culture to make something like that happen. But it's got to happen. I just think it does. We can't continue to do things the way we do because it hurts us in the long run. If we had better statistics, we'd be able to make better arguments and better quantify all of the good that we do. And the last thing I'll mention is, there's one thing I like to point out is that, people love to say, freedom isn't free. There's bumper stickers all over with that. Well, I like to counter, well, neither is justice. costs money. So if you think freedom is worth paying money for and fighting for, fight for justice a little bit too, and write a check for that every once in a while, and we'll all be a lot better off. So I want to thank Jim for inviting me here, and appreciate all the work that they do, and it was a pleasure.